Supreme Court allowed the appeals in RAJNISH Singh at the rate SONI versus State of UP, and the order dated April 2023 passed by the High Court of Judicature of Allahabad was quashed and set aside, and as a consequence, impugned FIR and all consequent proceedings sought to be taken thereunder against applicant were also quashed and set aside. Miss A, respondent and complainant, lodged an FIR in case crime 269 of 2022 dated 5th July 2022 against appellant at police station Bakewa, district Ottawa, alleging inter alia that she is resident of village Kudaria and was qualified with degrees in MCOM and B.Ed, and since 2008 she had been serving on post of lecturer in AFS Bhimora College in Lucknow. It was alleged that the accused appellant, sometime in year 2006, sneaked into the house of the complainant in night and subjected her to forcible sexual intercourse. She was neither able to scream nor could call out for help as the appellant had gagged her mouth, due to which her parents, who were also present in the house, were unable to get a wind of the incident. She warned that appellant that she would disclose about the incident to her family members, upon which appellant apologized profoundly and requested her to remain quiet and gave her an assurance of marriage. Complainant therefore never lodged any complaint, nor she did take any other action in respect of incident of sexual assault upon her. Appellant initially was working as constable in police department. Later in 2009, he joined as clerk in State Bank of India in Dhani branch of Maharajganj district. In the intervening period, intimacy between appellant and complainant continued to flourish. Appellant had once called the complainant to Maharajganj, where he made her to consume some intoxicant mixed with eno without her knowledge, which made her semi-conscious. Taking advantage, appellant subject her to forcible sexual intercourse. He not only videographed offending acts but later showed it to complainant, which she regained when she regained consciousness. Appellant complainant, fearing retribution in society, did not share information about said incident with anyone. Subsequently, the complainant became pregnant, which was confirmed with pregnancy detection kit. When this information came to knowledge of appellant, he mixed some medication in water and made complainant to drink it in order to cause her miscarriage. Since appellant continuously blackmailed and threatened the complainant using obscene videos, she did not tell anyone about the abortion. Supreme Court held in this case that the complainant has herself set up a case that there was a secret marriage ceremony between her and appellant. Therefore, in opinion of Supreme Court, even if the allegations made by complainant are accepted on their face value, it is evident that appellant and complainant were in long-standing live-in relationship during which they even performed marriage rituals, albeit informal in nature. It is right that there is a distinction between rape and consensual intercourse. This court in Deepak Gulati versus State of Haryana differentiated between mere breach of promise and not fulfilling a false promise, and held that an accused will only be liable if courts conclude that his intentions are mala fide and he has clandestine motives. It is therefore clear that accused is not liable for offence of rape if victim has willfully agreed to maintain sexual relations. The court has also recognized that a prosecutrix can agree to have sexual intercourse on account of her love and passion for accused. This court in Shiv Shankar versus State of Karnataka had quashed criminal proceedings on ground it is difficult to hold sexual intercourse in course of relationship which continued for 8 years as rape, especially when complainant therein had alleged that they lived together as man and wife. By no stretch of imagination can this court be convinced that present is a case where appellant is liable to be prosecuted for having sexually exploited or assaulted the complainant based on a false promise of marriage. The allegations of complainant are full of material contradictions and are ex facie unbelievable. Throughout the prolonged period of 16 years, complainant kept completely quiet about alleged sexual abuse meted out to her by appellant until she learned that appellant had married another woman. Further, in complete contradiction to case set up in FIR, complainant had on many occasions portrayed herself to be wife of appellant, and thus evidently they lived together as man and wife. Additionally, the long gap of 16 years between first alleged act of sexual intercourse continued relations for 1.5 decade till the filing of the FIR convinces the court that it is a clear case of love affair or live-in relationship gone sour. Court held that we are of the opinion that allowing the prosecution of the appellant to continue for the offences alleged under Section 376, 384, 323, 504, and 506 of IPC would be nothing short of a gross abuse of the process of law.